An Introduction to Constitutional Law, 100 plus Supreme Court cases everyone should know, by Randy Barnett and Josh Blackman. Lochner v. New York, 1905. In the late 19th century, the majority of bakeries in New York City existed in tenement house cellars because rents were low and the floors were sturdy enough to support the weight of an oven. These spaces, however, had never been designed for commercial use and had serious sanitary issues. To address these problems, in 1895, the New York State Assembly passed the Bake Shop Act, which established a detailed code of sanitation standards. At the behest of the Bake Shop Union, a clause limiting the working hours of bake shop employees, though not their proprietor owners, to 10 hours per day and 60 hours per week was also added to the act. At the time, small bake shops were largely owned and operated by Jewish, German, and other immigrants to serve their communities, and their owners fiercely resisted unionization. While large commercial bakeries could employ shift workers to meet the maximum hours requirement, small bake shops needed their few workers to man the ovens over a 24-hour period, while sleeping on the premises between their duties. In this way, the maximum hours provision of the Bake Shop Act had the effect of privileging corporate-owned unionized bakeries over their small immigrant competitors. Joseph Lochner's bakery was located in a nice shop in Utica, New York, not a crowded tenement house in New York City. Lochner, a German immigrant, deliberately violated the law in what was likely a test case arranged by him and his employee, Armin Schmitter. Lochner was indicted by a grand jury and then imprisoned for failing to pay the fine assessed against him. He contended that the statute violated the 14th Amendment's Due Process Clause. All of the justices agreed that the rest of the Bake Shop Act's regulation were legitimate health and safety measures within the state's police power. Study guide. Does the majority view freedom of contract as an absolute right that may never be regulated? Their only disagreement was whether the maximum hours provision was within the state's police powers. For the majority, the relevant question was this: was the maximum hours law, quote, a fair, reasonable, and appropriate exercise of the police power of the state, or is it an unreasonable, unnecessary, and arbitrary interference with the liberty of contract? In his opinion for the court, Justice Rufus Peckham rejected the claim that the maximum hours provision was a genuine health and safety measure. His analysis was based on facts provided by Lochner's lawyer's brief, which showed that the mortality rate of English bakers was lower than that of the general population and about equal to those of cabinet makers, masons, and clerks. This mode of argument would be a harbinger of the famous Brandeis briefs later filed by Louis Brandeis in defense of the reasonableness of progressive regulations. Having concluded on the basis of these facts that, quote, there is no reasonable ground for interfering with the liberty of person or the right of free contract by determining the hours of labor in the occupation of baker, Justice Peckham twice suggested that the law was enacted for, quote, other motives, unquote. By this he meant it was merely class legislation aimed at helping unions at the expense of non-unionized bake shops and their employees. Study guide. Do you see any important difference between the approaches favored by the dissents of Justice Harlan and Justice Holmes? In his dissent, Justice Harlan affirmed that, quote, there is a liberty of contract which cannot be violated, unquote. But then he contended that, quote, when the validity of a statute is questioned, the burden of proof, so to speak, is upon those who assert it to be unconstitutional. Harlan focused on different sources to conclude that Lochner had not met his burden. In contrast, Justice Holmes would have upheld the provision merely if any reasonable person could have supported the law. In his brief and pithy dissent, He charged the majority with, quote, deciding the case upon an economic theory which a large part of the country does not entertain, by which he meant laissez-faire capitalism. Holmes's reference to Mr. Herbert Spencer's social statics is sometimes misunderstood. It was not a reference to social Darwinism. In fact, Holmes was himself a social Darwinist. It was instead a rejection of Herbert Spencer's law of equal freedom, which claimed that, quote, each has freedom to do all that he wills, provided that he infringes not the equal freedom of any other, unquote, which Holmes paraphrases in the previous sentence. Lochner v. New York first became famous in 1912, when it was attacked by Progressive Party presidential candidate Teddy Roosevelt, who criticized the court's decision and praised the approach of Justice Holmes. As president, Roosevelt had named Holmes to the Supreme Court. Yet Holmes's approach would not gain acceptance by a majority of the court until the 1955 case of Williamson v. Lee Optical. When it repudiated its decision in Lochner, the Supreme Court would first move to adopt the burden of proof approach of Justice Harlan.